Good afternoon. This is Raymond DeLeon with SmoothOperationofLaw, and today I'm going to show you guys what a smooth operation of law cease and desist looks like. Now, before anybody gets all in a bunch about it, obviously in the top left corner of this document, you are going to address the parties that you are contacting. So if anybody says, well, where's your address bar and who are you talking to? You would insert it in that location. You will make your own address header. Now, I'm not going to obviously show this whole document. It's proprietary. But I'm going to get into some of the key elements and scroll through some of the key elements. This cease and desist comes with the arbitration clause that I've spoke on in my other videos. If you have any questions about that, go ahead and look up the other videos on this channel, and you'll see the ones that are listed as mentioning arbitration. So what you're going to first do is you're going to give the people a notice on your trademark infringement. And so this is some of the language that is associated with the notice. In the cease and desist, we are the Board of Trustees of the Your Name Trust, hereinafter referred to as trust. You, your judicial persons and organizations, and or your private and or legal entities, including but not limited to subdivisions or associations of said organizations, hereinafter throughout this agreement, in hereinafter referred to as you or your or judge hereinafter throughout this agreement. Okay, hold on. You or your or judge name trust recently discovered that your business is infringing on the property and trademark by using our mark. Trademark name in commerce for your benefit and gains. All right, so now I'm just going to stop right there. The language seems very open, very confusing, but you are going to designate by incorporation, by reference, all of the parties who you may be having an issue with that are using your name for gain. Once you fill that in, or create your document, that is what you will start off with after the, intro paragraph, which I didn't read. The reason why you need to mention all the parties is because if you do not incorporate them by reference, then they cannot be bound as a non-signatory to your arbitration clause. So you start off with who did it and what they did. Now, I'm going to keep moving. Obviously, we're going to give them a plain statement of facts. Here's an example. You are hereby on notice that your use of the trademark constitutes trademark infringement and a violation of my intellectual property rights pursuant to the Federal Trademark Act, right? Which is the Lanham Act. And the holder of a trademark has the exclusive right to do and to authorize any of the following: use, prepare derivative works based upon, reproduce, distribute, display, and perform trademark work. And then you're going to hit them with your demand. I demand that you cease and desist all use of the trademark. And then you're going to go into stipulations. And then you're going to get into the limited use that these parties are allowed to use that trademark in order to clear up the bullshit of their infringement. For example, if you tell a party, stop using my trademark, but they need to use that mark in order to authorize within their company or notify in a communication the stoppage of said use. Well, You need to be able to allow them to do that. So you are going to now turn it into a license agreement for them to stop using it. But you must incorporate performance or owed performance so that they can make the moves to stop using it. If you do not give them limited licensing, all they can do is freeze, and whatever is an infringing article will remain in the system, on their books, and they will just stop moving it or stop using it. But what you want is you want them to get the fuck off of using it completely in such a way where it gets removed from the system, because the same parties who authorized its usage probably can by themselves or can refer to another party who was incorporated by reference in your initial paragraph that I read. They can communicate with each other and get the authorized party to remove it out of the system. That includes a debt, that includes a case, that includes any type of marking or any infringing article that is not authorized by your trust and is infringing. Due to the fact that trademark infringement in itself is inherently a commercial activity, because you have to conduct commerce to infringe on a trademark. Everybody who's infringing has a waiver of sovereign immunity and are engaged in a commercial activity. Say it again. If somebody's infringing on your trademark, it's because they're doing business. And if they're doing business, then they're engaged in commercial activity, and there's no sovereign immunity once it becomes commerce. You can use the party's beneficial position, meaning they infringed and they're receiving a benefit, almost as if they got paid. And by you waiving their liability and giving them this notice that they need to stop and just cease and desist and then remove all articles or infringing articles, and then give them the limited licensing so that they have, per this agreement, the capacity to do such, you will be able to bind them the same way as if someone were to take $5 off of your table and you were to say, listen, you took my $5, that's theft, but if you are going to continue to hold that $5, I need you to mow my lawn. And if you have a record of that and they do not let go of that $5, then they have been given consideration, and it's reasonable consideration. That's how you kind of pay them so that you can require specific performance. If they don't sign this trademark agreement, remember I've said in other videos that there is what's called binding of a non-signatory, which if you look it up in Google, you will find that one of the 6 elements is assumption. That means if they receive the benefit and they undertake the benefit of a contract, they are bound to the contract even if they don't sign. But that can only happen if you have an arbitration clause built in to your agreement, which is what I'm going to do next. I'm going to scroll down to my arbitration clause, and no, I'm not going through every single element of it. Protections of the duties. Let's see. Dispute resolution. Okay. Woo. Now, obviously, my trademark licensing agreement over here with the cease and desist and ADR clause has different sections in it because we're in section 6 and we didn't get to see all the sections in between. Well, in the sections in between, I am tasking them with specific language based on the obligation that I just previously mentioned. They would be undertaken pursuant to receiving the benefit of that trademark. Okay, I'm just showing a little bit, and then I go into other provisions like preliminary injunctive relief, the process, their opt-out clause, waiver, and things like that. Now, this video is pretty much, you could say, a part 2 of the development of the trust video that I did last. The reason why I'm showing it is to give people an idea, not legal advice, but an idea of how Smooth Operational Law deals with their documents and crafts them. Okay? A proper irrevocable trust with a trademark in it and the proper cease and desist will allow for one to be able to, in the event that somebody uses your name, go after them, and it's not you directly, it's your trust that is going after them, because your trust owns the rights to the trademark. With that being said, being that the trust, again, is irrevocable, it is a separate legal distinct entity. So arbitration is going to be the venue you're going to go to. You are not going to go to litigation. Why? Well, let me give you an example of another thing. I mentioned in other videos that there is a Supreme Court case that came out March 20th. June 6th. There you go. 2020. It's called Allen v. Cooper. And in order for you to be able to sue a state entity, which if you can sue a state entity, what the hell is a bank or anybody else? You must have two prongs. One is willful infringement, which means you have to send a cease and desist. And two, there must be a failure to apply the adequate state remedy. That means if their laws say that there's a waiver of sovereign immunity, and the statutory law says that there's a waiver of sovereign immunity, but nobody in the state is obeying it, and yet you've given them a cease and desist to prove willful, the federal courts will enforce it. And the cool thing about Allen v. Cooper is that it's not really a new case. What it was it was a case that reaffirmed existing legal principles, because a lot of times you will send a cease and desist and you'll have a lawyer who will try to ignore it, not knowing that there is a constraint on the court's ability to behave, because if not, they receive a liability that's enforceable with Supreme Court precedents. A lot of times a lawyer's lack of knowledge of how liable they are will have them resist and create repugnant behavior. It's all monetizable to me, because I know how to go after that ass. And so your cease and desists need to be complex. The only way you learn that is if you actually learn contract drafting, enforcement, alternative dispute resolution, and you have to know intellectual property protection. I'm going to say a summary of this video in its totality. The elements that I chose to talk about in this video are some of the elements, some of the most key elements to being able to take someone who infringes on your mark and gets money, right? So it has to be commercial gain. And you can kind of like legally reverse judo it, where they think that they're just stealing, but now they're obligated based on how you create your cease and desist, and it's 100% enforceable and dictated by Supreme Court precedents. The Allen v. Cooper case reaffirmed existing legal principle to reaffirm to the public that, yes, this is in fact legal, but in a litigation sense. Now, we're going to arbitration, which means we take it one step further. And the reason why I want to do that, which I'll share with you, is because if Allen v. Cooper reaffirmed cases that already existed and the ignorance was apparent, then that means you may have the ignorance of other attorneys who didn't pay attention, and you might end up having to go to the Supreme Court again. Whereas if you put the ADR clause in there, you will be able to summarily get your situation adjudicated instead of having to wait 7 years, because all you're going to need is the Supreme Court cases and a contract. And it makes it that much easier. There's no 7 years. The enemy, whoever that may be, the infringing party, cannot sit there and kick the ball down and see how much money you have and do wasteful litigation because they have a bigger bank account than you. And they want to wait you out to see if you can fully enforce your trademark interests. A lot of times you'll see people sue people, even though they know they're not going to win, just to put a financial burden and bankrupt the other party. I'm just saying. So, again, Allen v. Cooper went through litigation, even though there was existing Supreme Court precedents. That's why arbitration is so important. That's why binding of a non-signatory is so important. That's why a licensing agreement with duties owed is so important, as a result of them receiving the benefit or continuing to receive the benefit of that trademark asset. It acts as payment. So here's the deal. If you're interested in this document and you're interested in just getting a copy, just not as legal advice, but you just want to see what it's made up of, or you're interested in the trust, this is not a class, it's not anything, you can call me and we'll see if we can get it to you. And do not use it to just launch. Use it as just, free speech. View it, check it against the internet, and do your research. Okay? God bless y'all. Have a good day. And if you're in another time zone, have a good evening, morning, and so on. Make this video viral. Subscribe to the channel. Like, share, so on and so forth. And now you got to see a real cease and desist based on the videos of what I've been speaking on before. Fully drafted and ready for consumption. That means optical consumption. That's it. Optical consumption. That's why it doesn't have an address. I'm not telling you to send it to anybody. Not because it's defunct, but because you ain't going to fucking wrap me up. You ain't going to wrap me up with, he's giving legal advice. No, I'm not. This is a vlog. Entertainment purposes only. Go find yourself some legal counsel. They might look at it and just go, whoa, who the fuck wrote that? That shit's amazing. Yeah, no shit. But I am not liable. Never. All right. Bye.